So it's been a couple of weeks now since the judge's ruling in our case, providing clarity that XRP is not a security, which we're very happy about. It gives us a lot of clarity in terms of how Ripple will operate its business going forward. And we are, re-engaging with a lot of the U.S. market. But really, a lot of our growth over the years has been outside of the U.S. I think that's reflective of where there is regulatory clarity, places like the U.K., Europe, Singapore, Dubai, in the Middle East. These are jurisdictions that have provided clear frameworks and rules. So that's where we see a lot of growth for our business around payments.
Yeah, and Monica, the UK was singled out as one of the big countries in the Statista report as one of the big hubs for fintech. Is that a country where you're looking to kind of up your investment, particularly as the UK wants to become a crypto hub with specific regulations tailored to crypto companies? Is that where you're looking to put more of your operations going forward?
Absolutely. So our large hub offices, of course, we have a presence in the US, but our presence in London has grown significantly over the years. That office has more than doubled in size, and we have a pretty large footprint in terms of our customer base throughout Europe and the Middle East. Dubai is another key office for us.
A cryptocurrency attorney has stated that it would be beneficial for the Ripple and XRP community if the SAC were to appeal the decision sooner rather than later. A crucial decision was handed down on July 13, 2023, regarding the ongoing litigation between the SEC and Ripple Labs. The United States Securities and Exchange Commission had brought charges against Ripple Labs and two of its top executives, Bradley Garlinghouse and Christian, a larceny alleging that they had illegally offered and sold securities. The Honorable Annalisa Torres, a district judge for the United States District Court for the Southern District of New York, presided over the case. The ruling of the court was inconsistent, as it both granted and denied summary judgment applications brought forth by the SEC and Ripple. The move for summary judgment that the SEC made in regard to the institutional sales was granted, but the motion was refused for other reasons. In contrast, Ripple's request for summary judgment was granted in regard to the programmatic sales, the other distributions, and the sales that were made by Larson and Garlinghouse, but it was refused in regard to the institutional sales. The request for summary judgment that the SEC filed against Larson and Garlinghouse regarding the aiding and abetting claim was likewise refused by the court. The judge's observation that XRP does not in and of itself embody the Howey conditions of an investment contract is a major takeaway from the judgment. This statement suggests that the court does not see XRP as a security because it is a digital token and does not embody these characteristics. In light of the fact that the summary judgment only addresses a portion of the case, the SAC retains the right to lodge an interlocutory appeal. An appeal of a judgment that has been rendered before the entire trial has been completed is known as an interlocutory appeal. It gives an appeal court the opportunity to consider a portion of the case before the conclusion of the trial. A party has a limited amount of time from the moment the order or judgment is entered to file a notice of appeal, and that period is often 30 days, although the schedule for filing an interlocutory appeal might vary. In general, a party has a limited amount of time to do so. Given that Judge Torres issued her judgment on July 13, 2023, the Securities and Exchange Commission would still have time to submit an interlocutory appeal as of the 26th of July 2023, assuming the standard 30-day rule holds. However, appeals to the appellate courts are not always willing to hear cases that are being considered at an earlier stage. In most situations, they are only allowed under specific conditions, such as when the matter at hand has a considerable impact on the outcome of the case, or when it raises a significant point of law that could have implications for other cases. A pseudonymous cryptocurrency attorney who goes by the handle Metalaman recently expressed his thoughts on the possible next actions the SEC could take in the current Ripple lawsuit through a series of tweets. He presented an overview of the 4 distinct possibilities that the SEC might be taking into consideration. The first choice available is to submit a request for an appeal at an earlier stage, as there has been no entry of a final judgment as of yet. The SEC does not have the authority to appeal at this stage unless it receives permission to do so from both Judge Torres and the Second Circuit Court of Appeals. In order for the Securities and Exchange Commission to be granted this authority, they would need to demonstrate that the finding in question involves a controlling matter of law, that there are substantial grounds for difference of opinion on that question, and that an immediate appeal may materially advance the case. This preliminary request does not have a hard and fast deadline, but it ought to be completed as soon as possible, preferably within a month at the most. If Judge Torres rules in favor of the SEC, the Commission would have 10 days to appeal the decision to the Second Circuit. The second alternative is for the SAC to proceed with a trial on the accusation of aiding and abetting against Larson and Garlinghouse, and then to file a standard appeal after the conclusion of the trial. The third possibility is for the SEC to withdraw its claim against Larson and Garlinghouse at this time, and instead file an appeal right now without first obtaining permission to do so. The fourth and final choice is to reach a settlement with the defendant. Metalliman is of the opinion that the SEC will most certainly pursue the first available alternative, which is an interlocutory appeal, because SEC Chair Gary Gensler is under a great amount of political pressure to get the Torres judgment overturned as quickly as possible. Cases brought by the SEC against other large cryptocurrency exchanges such as Coinbase, Binance, and Bittrex are also being impacted by the judgment. There are also serious repercussions for politics stemming from this case. The SEC is being made to appear bad because cryptocurrency exchanges all around the world are relisting XRP. Congressman Richie Torres, along with other progressives and others, have been given the confidence to step up. Their criticism of Gensler. This predicament is proving to be quite embarrassing for Gensler and his supporters. Metalliman is of the opinion that reaching a settlement at this juncture is quite unlikely. It is difficult to conceive of the SEC reaching a settlement with Ripple and then permitting the Torres precedent to go unchallenged in the appeals process. Getting the Torres judgment overturned is essential to the success of the SEC's regulation. By enforcement strategy directed against the cryptocurrency industry. According to Deaton, the appeal by the SEC will not be a setback for XRP holders. A prospective appeal by the United States Securities and Exchange Commission may have a detrimental impact on the cryptocurrency market. Pro-XRP lawyer John Deaton has made it plain that even in the event of an appeal by the agency, it would not significantly damage XRP. This comes amid rumors that a potential appeal by the SEC could have a negative impact on the cryptocurrency market. Stock prices fell by 67 cents following the decision of the judge that the programmatic selling of XRP tokens through exchanges does not qualify them as securities. That's all for now. Thank you and see you in our next video.